31 of the House of Commons Standing Committee on Justice and Human Rights. Today we have MP Pam Damoff, who is replacing Mike Kellaway. Welcome back, Pam. So great to have you back. To ensure an orderly meeting, I'd like to outline a few rules to follow. As our witnesses know, there are interpretation services available. You have the choice at the bottom of your Zoom screen. Select the language that you would like to listen to. You can speak any language that you'd like. Mr. Clerk, if you can just mute Ms. Hardy, because I think there's some, there we go. Thank you. And when you are not speaking, which gets to my next point, when you're not speaking, you should be on mute, and please do wait for me to recognize you by name before you start speaking. A reminder that all comments by witnesses and members should be addressed through the chair. With respect to a speaking list, the clerk and I will do our best to maintain one and make sure that everybody's accommodated. Now, before we get to our witnesses today and we start the hearing, I'd like to get the committee's approval for the operational budget that was distributed to members yesterday. The budget is in the amount of $1,775. It will serve to pay for our expenses for the current study. Do I have the members' approval? With a thumbs up?
No.
Monsieur Fortin? Oh, mon Dieu. Merci, monsieur.
Thank you, Mr. Fortin.
So carried. Thank you very, very much. So now I'd like to welcome our witnesses. We have appearing as an individual, Mr. Todd McCarthy, who is a barrister and solicitor. We also have the Professional Transcriptionists and Court Reporters Association of Ontario, represented by Joanne Hardy, who is the president. To the witnesses and to members, I will show you. You'll have 5 minutes to make your opening remarks. I have a 1-minute time card and a 30-second time card to help you keep track so that we can keep our meeting on track. And with that, we'll start our panel with Mr. Todd McCarthy for 5 minutes. Go ahead, sir.
Thank you very much, Madam Chair, and good morning to you and members of the committee. It's an honor and privilege to be asked to appear before you today to address the committee on the specific issue of the impact of the COVID-19 pandemic on the judicial system in Canada, and especially any delays or impacts on trials in the criminal justice system. Let me first address the challenge. A year ago, the courts across the country were virtually shut down because they were not set up for remote practices to any great extent. And for almost 3 months from mid-March into late June or early July, criminal, family, civil, and child protection cases that could not be adjudicated or dealt with. And that led to the creation of a large backlog. And it also had the effect that negotiations with respect to those cases often shut down because without the access to adjudication or the threat of adjudication, parties often aren't motivated to resolve their matters. And now we are in a similar position because although we've adopted remote practices in our trial courts in Ontario, that's the Ontario Superior Court of Justice. Across the country, it's called the Court of Queen's Bench in many provinces and so on, the Quebec Superior Court. All of those are trial courts. They're Section 96 courts. The judges of those courts, while subject to the administration of justice jurisdiction of the provincial governments, where they sit under Section 92 of the Constitution Act, they are Section 96 appointees by the federal cabinet on the advice of the federal minister of justice. And they are judges of general jurisdiction, dedicated, hardworking judges working with counsel and pivoting to remote practices in this pandemic very successfully, I might add. But more recently, because of the stay-at-home orders in Ontario, among other provinces, court staff can't get into the courthouses. And therefore, the Zoom technology can't be dealt with at home by those dedicated court staff. And therefore, the judges are adjourning or canceling many hearings in all these areas of the law. So what's the impact of that? Because, of course, as a general jurisdiction, the Section 96 courts across the country and the judges of those courts decide cases in the matters of criminal law, family law, child protection, and civil justice. And they could be hearing a civil pretrial in the morning dealing with a child protection midday and an urgent bail hearing in a criminal matter at the end of the day. Very hardworking and very diverse aspects of the law come before those judges. And what happens when you have this kind of challenge? You have backlog, you have growing backlog, and it's very, very difficult to deal with that presently, and it's only going to get worse. So that is the problem. The problem is compounded by a policy choice made by our Supreme Court of Canada in the case of Jordan and Her Majesty the Queen in 2016. The Supreme Court of Canada decided that the right to trial within a reasonable time, the Section 11B Charter right, a right under our supreme law of the land, was such that it would be specifically time limited with a ceiling of 30 months for a trial in the superior courts of the country after a preliminary inquiry, 30 months. In Jordan, he was charged with multiple narcotics trafficking offenses. And after 44 months that it took to try him in a superior court, his charge was stayed by the Supreme Court of Canada. He was allowed to walk free. And the prosecution of that case was not successful just because of the delay due to that charter breach. Now, I am proposing that the committee seriously study a solution, however temporary it might be, and it's called the notwithstanding clause, also part of our supreme law of the land, also part of what policy choices are possible. And it preserves parliamentary supremacy. And I can answer more questions about it, but the courts are not always right. To quote the late Professor Hogg, let us remember this, that it is wrong to assume that a judicial decision on a rights issue closes the debate on that issue. Citizens and their elected representatives, this parliament, will inevitably want to continue the debate, and in some cases, there'll be a strong sentiment in favor of reversing the judicial decision. And that is what the notwithstanding clause or override clause does. It is a legitimate constitutional instrument, uniquely Canadian, and endorsed by the late Professor Hogg as a useful instrument. I ask this committee, subject to questions you may have, to consider how this can be thoughtfully invoked for 5 years, because it does expire after 5 years if not renewed, to deal with this crisis in our trial courts that affects criminal, civil, family, and child protection cases. Thank you.
Thank you very much, Mr. McCarthy. You were right on time. I really appreciate that. We'll now go to Ms. Hardy. Ms. Hardy, just before you start, is that a painting of a rose behind you? It's a very beautiful painting right there. That is exquisite. Ms. Hardy, you will have 5 minutes. Take your time, speak slowly and clearly, and we'll get through this. Thank you. Please go ahead.
Good morning. I hope everyone can hear me properly because I don't have the proper headset. Thank you, members of the committee, for inviting me here today to represent the Professional Transcriptionists and Court Reporters Association of Ontario in discussion with respect to the impact of COVID-19 on the judicial system. I'll read this statement in order to stay within the 5-minute time allotment. Just a very brief intro. PT Creo is a not-for-profit business association with membership spanning across the province of Ontario. Through 55 years of operation, we have adapted and evolved to meet many challenges. Our mandate has never changed. We are committed to ensure the profession of court reporting and transcription services are provided to the highest professional standard. Now we faced our biggest challenge. In Ontario, from the onset of the pandemic, the justice system went into immediate action. Lockdowns and restrictions because of COVID accelerated the rapid modernization of the courts and gained immediate and positive response. The path to modernization went straight to Zoom and teleconference calls as a way to exist in a virtual world that COVID created. I'll just make reference to Zoom because it's more efficient, but all these comments apply to teleconference as well. So to zoom directly to the point, as a reaction to COVID, stakeholders and decision makers in the understandable rush to ensure the courts remained functional overlooked the most important foundation of the justice system, the official court recording, and replaced it with a one-channel Zoom solution. Without a stable 8-channel audio recording that is properly preserved and securely stored, a verbatim certified transcript is almost impossible to produce. The voice of a victim or a witness to a crime can no longer be heard if words are lost on a one-channel recording. This is our main concern and our focus and the reason we appear before you today. By regulation in Ontario, a transcriptionist must be authorized by the Ministry of the Attorney General to certify court transcripts, here referred to as ACTS. Here are some examples of the problems with Zoom. On one channel, you cannot separate speakers if they talk over one another. On one channel, if there is nothing to identify same gender speakers, then they are simply noted as unidentified. On one channel, dogs are barking, babies are crying, doors are slamming in the background, dishes being washed are just a few examples of interference. At times, Wi-Fi connections fail, audio becomes unstable, sound becomes distorted, words are lost or become garbled and warbled. The audio cuts in and out. There have been bail hearings where lawyers are sitting in their cars on cell phones. Sometimes participants phone in, often from custodial institutions. Sometimes they appear via Zoom, but the most a transcript can reflect is that they are all participating from multiple unknown locations. Ultimately, transcripts must reflect the truth, and deficiencies created by lost audio must be noted. Justice is not served if a transcript cannot be certified to verbatim accuracy. We support whatever makes courts run smoother and quicker, but by doing so, by making those things priorities, we have sacrificed the most important element that keeps the justice system safe. The Liberty Digital Recording and Software System that was implemented across Ontario in 2010 by the original MAG and Court Reporting Services team was almost flawless. We had moved from 4-channel analog tapes to state-of-the-art digital recording and transcribing equipment across 8 channels. Speakers could be identified, voices separated, volumes controlled. This push to modernize the court during COVID has stripped away any progress and effort and time that went into developing the state-of-the-art digital recording technology and has pushed the fundamental importance of the checks and balances in the court system to near non-existence. We read the article in the National Post, which references comments that Supreme Court Justice Mona Lynch made before you, and I quote, "A colleague of mine was conducting a family hearing by phone, and one of the parties said, 'Oh, just a minute,' Lynch said. There was silence, and then she heard, 'Can I have a medium double-double?' She called the incident amusing and quintessentially Canadian, but said it also reveals the lack of respect and attention participants pay when the court proceedings are not in person in the courtroom with the judge." We agree with Justice Lynch in that comment, and we are here to answer any questions the committee has. Thank you.
Thank you very much for that, Ms. Hardy. You're right at the 5-minute mark. Really appreciate that. We'll now go into our first round of questions for 6 minutes each, starting with Madame Findlay. Please go ahead.
Thank you very much, Madam Chair. Thank you to the witnesses for being here. We really do appreciate your expertise and perhaps the expression of some frustration. So we do appreciate it. For Todd McCarthy, I know you're an accomplished litigator, so I do thank you for sharing some of your thoughts with us here today. At our last meeting, we heard from a witness representing the Canadian Bar Association about some of the challenges involved in virtual hearings, including a lack of formality. We're just hearing that from Ms. Hardy as well, when separated from the trappings of a courtroom. The CBA's report submitted that credibility assessments can be difficult when conducted remotely. Could you speak from your experience about some of the difficulties Zoom hearings pose for counsel, witnesses, and the courts in terms of assessment of credibility?
Certainly, through you, Madam Chair, to Ms. Findlay, it's an excellent question, and to Ms. Hardy's point and her reference to Justice Lynch, a lack of decorum is a serious problem, and also the ability to assess credibility fairly, where credibility is often the essence of how any case, criminal, civil, family, or child protection, is adjudicated. So, the remote process, the Zoom hearing, the teleconference, has a place and will continue to have a place, and we've embraced it, and the pandemic has expedited that. But to say that should be the default position, especially where credibility is so crucial. We cannot dispense with in-person hearings, of course, and we need to get back to them because both decorum and the issue of credibility, the sense of being heard in a courtroom is all about respect for the rule of law, for the judicial decision-making process, for having been fairly heard. All of those things affect the participants in the process and their view of whether or not fairness and justice has occurred in a proper form. I mean, the reason our forebears built such grand courthouses across the country, many of which are still with us, is because we are saluting the rule of law. We are deferring to the rule of law and where the rule of law is applied. And that decorum is very, very important. And we always say about judges, they write for the loser, right? They write for the loser. So you have to explain why the loser lost, and you're writing for the public as well. And the credibility determination is always a part of those reasons.
Thank you. And do you, when you're prepping witnesses, for instance, do you pay attention to things like lighting and camera angles when you're dealing with a virtual setting? And do you think these elements that are unique to virtual hearings could end up affecting the outcome or fairness of a trial?
Absolutely. Not everybody is equipped with a grand computer room and multiple screens. Some are calling in from their phones, and it depends what kind of phone they have. So this then creates an inequity. And we would never want a witness to be more likely to be believed just because they have better technology, any more than we'd want them to be more believed if they are wearing fancier clothes. That should not be the measure of credibility.
One issue I think we're all rightly concerned about is access to justice. Justice Canada has estimated that 50 to 80% of litigants in civil and family courts are self-represented, numbers that could continue to grow under pandemic stress. Former Chief Justice McLachlin has called this a crisis. Do cases involving self-represented litigants take longer and thereby contribute to the backlog? And what, in your opinion, can be done to improve access to justice for these litigants?
It's an excellent, through you, Madam Chair, it's an excellent question. Self-represented litigants, as much as it is their right to proceed without counsel, and that raises issues of the cost of legal services, which is another matter where we could talk about a duty counsel and so on. But it is a serious, serious problem. And in fact, right now, it is leading to great backlogs because, of course, many self-represented litigants don't have the access to the technology, even if the court does. And also, in fairness to the judges presiding, even at a pretrial conference where nothing is being specifically decided with a self-represented litigant, they want to record these. And normally those are done in open court with a court reporter present. The problem is that we have judges who say, I cannot and will not fairly hear this self-rep case in family law or any other matter because I have to be able to have it recorded. It's part of doing the job thoroughly. So this is a serious problem. The self-represented issue requires in-person attendance to return, or at least requires our court staff to be able to come to court and utilize Zoom technology properly.
Mr. McCarthy, I only have a short time left, or we do. So I would just like to give you the floor to talk a little bit more about what you think the federal government can do to address the backlog. You've mentioned the notwithstanding clause, an interesting idea. So we have about 30 seconds, not much, but can you just speak to that briefly?
I'm proposing a conversation between different branches of government. The courts are not always right. It was a well-intentioned decision, Jordan, but it's adding huge problems because as courts of general jurisdiction, our trial courts have to then give priority to criminal cases. Many of those are being stayed because of this time limit. And then those judges are not available for family, civil, and child protection cases, which are also very, very important. So we need to take a pause. And the Parliament of Canada has the last word on that, not the Supreme Court of Canada, at least for a 5-year timeout on this. That should not be the preserve of the courts to make that policy decision. And the Charter says as much. But somehow the notwithstanding clause gets a bad word or a bad name. It's not. It's a fair, balanced conversation between branches of government on an important constitutional issue. And it's in the Constitution. It's in the Charter. It's there to be rarely used, but appropriately used in a crisis before the court such as this.
Thank
Thank
you.
you.
Thank you very much.
Thank you. Thanks very much, Mr. McCarthy. We'll now go on to Mr. Maloney for 6 minutes. Go ahead, sir.
Thanks, Madam Chair, and thank you to both of our witnesses. Don't have a lot of time, so I'm going to try to jump right in. Mr. McCarthy, to you, first of all, good to see you again. It's good you're here, and thank you for your presentation. I'm particularly happy you're here because whenever we have discussions about court systems and issues in the courts, the default position is criminal courts. You're a civil lawyer like I was, and we tend to be underrepresented, so I'm pleased to see you here speaking on our behalf. Look, there's a lot of discussion about what's going on during COVID, what impacts. You've talked about them. Ms. Hardy's talked about them. Hopefully this is over and we're not going to be dealing with these unique situations like Tim Hortons anymore. The bigger issue in my mind is what takeaways are there from this that we're going to adopt going forward in the system, because virtual hearings are going to become part of our process going forward. I think the default position should be in-person hearings, not just trials, but pre-trials, discoveries, motions, all proceedings, and you should have to present an argument why it should be otherwise, because as you said, Mr. McCarthy, deadlines impose pressure, and that's at all stages. So what permanent features do you see going forward that have been adopted during COVID?
Well, definitely the Zoom hearing for matters that are based on a paper record are ideal, because you can't just make written arguments on affidavits and then have the judge pop out a decision. The exchange between bench and bar is very important, especially when there may be some impact on the development of the law. But that can be done effectively with a Zoom hearing, a motion for summary judgment, a pretrial where everyone is represented. And we know we all have these Canadian winters that often delay cases that have to have occurred in person. And the Zoom technology will, I think, next February and the February of 2023 be very welcome when, for example, we're not flying from Toronto to Pembroke in the province of Ontario just to do a summary judgment hearing that could be done by Zoom. But most certainly, the beauty of that is that court resources can be better used by the combination of embracing Zoom where appropriate and continuing with it, but also the default for in-person hearings. And the rules committees provincially are grappling with how to deal with this, as you put it. Should it be the default to in-person or the default to Zoom? And I think I agree with you, Mr. Maloney, through the chair, but I think that it should be for some types of processes, Zoom should be the default position.
Yeah, we agree on that. You know, I think back on my trips to Haileybury for a 1-hour pretrial. You know, it'd be a 13-hour day, but my clients didn't like it. But there's some importance about being there in person. And you talked about deadlines like trials. There's some threat when somebody has to, you know, incur those costs to go do that. It creates pressure that gets cases resolved, and that shouldn't be lost. But I'm glad to hear the rules committee's dealing with that. The other thing, and I just want your thoughts on this. If you're having a Zoom trial or a Zoom process and it's appealed, right now, when judges go out of their way to make findings based on credibility to make the decisions unappealable or hard to appeal. But in a world now where things are virtual, do you see lawyers asking that things be recorded virtually, which would then allow appellate courts to be asked to consider reviewing findings of credibility because they have the opportunity to look at witnesses?
Well, to your point through the chair, Mr. Maloney, the situation is exemplified by a recent trial that was done by Zoom, a public trial in the civil justice system for Breezy versus Chu. And there was a huge issue of credibility. Who saw what, who recalled better, and the case was 12 years old when it was heard. And whether or not there's an appeal on that, as in any case involving credibility, the issues of credibility really are for the trier of fact who saw and heard the witness. The appeal court, as you know, is only going to review a transcript. There's not going to be a change in the practice that somehow they get to see a recording of the original witnesses, because the trial judge is always in the better position to deal with that issue. But appeals will continue to be.
I could see lawyers asking for the Zoom proceeding to be recorded so that process can be addressed. But I agree with you. And sorry to interrupt, but I only have a few minutes. And I do want to move over to Ms. Hardy if I can.
Sure.
Ms. Hardy, I believe I know you represent transcriptionists and court reporters. I'm not sure how many of the court reporters in courthouses you represent. I'm not sure if they're represented by a different group or not. But the question I have for you is, one of the things we've seen during this pandemic is there's issues of safety, and everybody, had to go home and work from home. So what's happened in Toronto, at least, and Mr. McCarthy will agree with this, I think, is a lot of the judges are working from home and working remotely on Zoom. But the court reporters, for example, have been forced to go into the courthouses because they don't have the technology at their disposal, which puts them on public transit, which puts them back in the courthouses. So right now, during this third wave lockdown in Toronto, for example, the court reporters are going downtown to the courthouse. What measures can be taken to address that?
We have had some indication that reporters are working from home, and the DRD, which records the proceedings, is then the virtual courtroom, and it's turned on wherever the reporter is. We've heard that.
Yeah, okay. How many courthouse reporters do you represent?
None.
Yeah, okay. All right. Thank you. I think I'm out of time.
The ministry, I guess, is responsible for that.
Right. Okay. Thank you both. Sorry for having to rush through it, but time's limited. So.
Thank you very much, Mr. Maloney. Thank you, Ms. Hardy. I will now go to Monsieur Fortin for 6 minutes. Go ahead, sir.
Merci, Madame la Présidente. Alors,
Thank you, Madam Chair. Thank you to the witnesses for being here with us today. I have a few questions for Mr. McCarthy. I'd like you to talk to me a little bit more about this conversation or dialogue you'd like to have between the different branches of government. To what extent could this dialogue help progress the administration of justice on this issue of trials that are partly in person and partly remote?
Through you, Madam Chair, merci, Monsieur Fortin. The issue of whether the trial is remote or in person is equally affected by the fact that judges who have general jurisdiction have to be deployed for criminal cases first. Otherwise, they get stayed if they've taken too long to get to trial. That's what Jordan does. And then that has the ripple effects across the system, because a lot of times they can't get to them in time, and then they're stayed anyway. Legitimate prosecutions are stayed. And then those judges have been deployed and others are kept waiting in all the other areas of law within the jurisdiction of those courts: family, civil, and child protection. There's no right to a trial within a reasonable time in those other areas of the law. So the conversation between the branches of government that I propose is, thank you for your opinion court from 5 years ago, but you didn't see this pandemic and the delays associated with it coming. We, the elected parliament, are saying it's time for a pause, a timeout. We're going to suspend the effect of that decision, and let's work toward new solutions. Allow the judges to do their job with counsel. And we have dedicated, hardworking judges who are doing the best that they can, but the system is falling apart. And we need to be able to take a pause so that criminal cases are not put in peril by this, court-imposed time limit. And I have to say, Monsieur Fortin, the courts are not always right. Our Supreme Court of Canada in 1929 famously said women are not persons for purposes of Senate appointments. The courts are dreadfully wrong sometimes on matters of public policy. So they're not coming from Mount Olympus with great wisdom. They, as Professor Hogg pointed out, they have their own failings. They're not perfect. They don't pretend to be perfect. Many of them don't want awesome powers. The charter provision for the override is there for this conversation that has to happen in times of crisis. It's not the War Measures Act. It's a balanced conversation about how to carefully use scarce judicial resources in our trial courts so that all of our citizens have access to justice.
Je comprends. Il y a seulement le king.
I understand. Only the king can do no wrong, right? Not the judge. That being said, Mr. McDonald, pardon me, Mr. McCarthy. So what we're hearing is that the current situation, we're hearing that virtual is not always the solution. There's the evaluation of the credibility of the witnesses. This is a problem. It's a human science law. And so indeed, being in person is essential in most cases. But we're currently living through a situation where we have to question the usual way things happen in courts. And one could bet that in the years to come, there will still be virtual meetings. There'll still be in-person ones too, but the virtual ones will remain, and probably more and more of them will happen. And so in that sense, the crisis that we're living through now, yes, it's a one-off, because over the course of 1 or 2 years, we've completely changed things. But in the long run, at least a part of this will remain this way that justice is administered. But when you talk to us about a dialogue that would put aside the timelines imposed by the Jordan decision, well, in the short term, this could work. But in the long term, I think you'd agree with me that we can't go back to 6, 7, 8, 9, 10-year periods before making a decision. It has to be within a reasonable time. And so in that sense, I feel that the Jordan decision was well-founded. But what do you think? In the long run, could such a dialogue to put aside the Jordan decision be good, or shouldn't we find other ways to be more efficient and working with the in-person and virtual meetings?
Thank you. Through you, Madam Chair, Monsieur Fortin. It's a great question. Remember, this is temporary. The charter provision for the override is 5 years maximum. It will expire if a future parliament doesn't reenact it, and Jordan would be the law again. So it has its limitations. And I'm talking about a timeout in this conversation. This 30-month ceiling, which is leading to the monopoly for criminal cases by judges of general jurisdiction, the ignoring of many other cases, and losing legitimate prosecutions just because they fall outside this timeline, is not tolerable in the crisis of COVID-19 delays to the justice system. And the people of this country, through their elected representatives, I submit through the charter, ought to be able to be part of the conversation, say, we're not going to put any time limit right now, but you're right. And in the long run, there should be time limits. In a perfect world, there should be. And the right is not there to be ignored. It's just to be paused until we get through this terrible crisis in the courts.
Combien de temps selon vous?
How long do you think?
Time.
Merci, Madame la Présidente.
Merci, Monsieur Fortin, for votre patience. I appreciate it. We'll now go to Mr. Garrison for 6 minutes. Go ahead, sir.
Thank you very much, Madam Chair. I want to start with the question to Ms. Hardy, because my late mother would never forgive me for not talking to transcriptionists and reporters after her long career as a court reporter in the family court. In your presentation, you did a good job of outlining some of the challenges that have been presented by the change to the use of Zoom technology, I guess we'll just call it that. I'd actually like to hear a bit more about both short-term and long-term solutions to those problems from your point of view.
Our point of view is we would like the ministry to respond to our concerns. That's the major point. They haven't. And we just simply want the audio recording to improve and to find a platform that would accommodate 8 separate channels of speakers. Because right now, everything is coming through on that one channel, and the transcripts they can't even be certified because there's so much interruption, cutting out, Wi-Fi becomes unstable. It's a serious concern, and transcripts are supposed to reflect what happened in a person's experience in the justice system. We don't have the death penalty, but if you don't get a good transcript, there are real severe repercussions. We're just asking. That's our one only concern, is just let us do our job. We can't right now.
Right now, is this a matter of which platforms people are choosing to use, or the fact that there isn't a platform which exists?
There isn't one. It's not being connected. It's not being integrated into Zoom. The platform that exists, or the system that exists in every courtroom, has not been integrated into the Zoom platform. So we have one channel that we can transcribe from, and that's it. And it's becoming impossible. It's been 14 months, and we just want to know where it's going. Like, why can't they fix this now?
And have you seen any evidence that anybody's actually working on developing either the improvements to Zoom or another platform that would do this?
Look, we do a lot of research in our association. We've been tracking things, keeping on top of stuff, reading articles. Yeah, and I guess snooping, because we're not getting any kind of really direct response from the ministry. So yes, there is a platform available. We don't know why or what's happening. We don't know what the status of it is, but it's been 14 months, long time.
So let me just, I want to be very clear on there. So you're saying that from your research, you believe there is an alternative platform that would allow you to do your job correctly at this point?
There is an option because Liberty Recording Services now provide all of the systems in the courtrooms. And we believe there's a platform that they have available that would connect right now.
Okay,
I think
that's very important information for us. And I thank you for bringing it to our attention.
Thank you.
I want to turn to Mr. McCarthy at this point and ask whether you had the same concerns about the Jordan decision before the COVID crisis, and whether you would have been suggesting the same temporary solution of using the notwithstanding clause were we not in this COVID crisis.
Through you, Madam Chair. Thank you, Mr. Garrison. That is a very important question. The Jordan case was controversial, and it imposed, with its time limits, exact time limits of 30 months or less, a great burden on the courts, and the deployment of judicial resources to criminal matters did begin to delay judicial resources for other types of cases. So that it was the immediate effect of Jordan, but I wouldn't have recommended it without the COVID-19 pandemic. I'm addressing the use of the notwithstanding clause to overcome it as a temporary measure because of the severe impact of the COVID-19 pandemic. And of course, as I've indicated in my written paper submitted to the committee, there's no doubt that the court was well-intentioned in trying to give real definition to the 11B right to trial within a reasonable time. That's what courts can and should do. But when something unexpected comes up, we can't, the Supreme Court of Canada can't reverse itself until a case comes up before it in particular circumstances. And you might well get 5 of the 9 judges in a COVID-19 type of case say, well, wait a minute, the Section 1 of the Charter says that these rights are subject to reasonable limits prescribed by law and so on. So you might get a different result in a certain fact situation, but how long do we wait for such a case to get all the way to the Supreme Court of Canada, right? So judges are not active. They have to wait for a case to come to them, whereas the Parliament of Canada can be proactive. And the time is not to sit back and wait for a new precedent that might go a certain way. The time to act is now. Be part of the conversation. That is your right and role as parliamentarians. That is what I think our citizens expect of our parliamentarians. It's a conversation that has to happen that probably wouldn't have had to happen in non-COVID times and won't have to happen again. I think to Monsieur Fortin's point, it doesn't have to be permanent. Jordan can become the law again if this Parliament decides to suspend the effect of it for a period of time. And you can actually invoke it for less than 5 years if that's what you put in the legislation.
Thank you very much, Madam Chair. I believe there's so little time. We'll wait for the next round.
Thank you very much, Mr. Garrison. I will now go into our second round of questions for 5 minutes. Mr. Cooper, please go ahead.
Thank you, Madam Chair. Thank you to the witnesses. I'm going to direct my questions to Mr. McCarthy, and I just want to pick up on the Jordan decision. It goes without saying that the presumptive ceilings, when they were established, obviously that was long before the court could have possibly contemplated something like COVID. So can you speak to how the courts have addressed COVID in the context of Jordan to date? Anything we should be looking for?
Well, certainly remote appearances on routine criminal matters are being embraced. They were looked at even before COVID, but now they're being embraced more than ever. Why should someone, have to be brought from a distance while being in custody if they were denied bail pending trial just to make a 1-minute court appearance to set a new date for a preliminary inquiry or a trial? That just is a waste of time and resources. So even in criminal cases where the liberty of the subject is at play, the liberty of the subject being a very, very important consideration. In person is not always required. And those kinds of changes will be, and should be permanent. But let's face it, credibility is often a big issue in criminal trials. And so the courts have been trying to get to as many in-person trials as they can, but the COVID-19 restrictions, especially in Ontario recently, have kept pushing back the ability to have, for example, in-person jury trials until, at this point, not until after June 7th in most venues in Ontario and July 5th in Toronto and Peel. So the courts are just dealing with it. They're hoping for plea bargains. They're hoping for resolution. But, I can tell you, having done all kinds of litigation, I am a civil litigation specialist like Mr. Maloney was, but I did defend our fellow citizens accused of offenses. And boy, what a great defense to be able to raise the 11B defense. And I successfully raised it for many of my clients, rightfully so, invoking a proper charter right. But should this become a mass amnesty? Does this create a scenario where we have to virtually or otherwise deploy judges for criminal cases to save them from being stayed and then not get there in time, and in the meantime have ignored other cases? That's why we're in this crisis, and it's going to get much worse before it gets better. The courts are doing the best they can, but they need help from this Parliament on this issue.
Thank you for that. I want to ask you a little bit about virtual hearings and some of the concerns that have been raised. For example, at our last hearing, Madam Justice Lynch raised concerns with regards to the open court principle and whether that could be truly respected in the context of virtual hearings. There are issues of privacy concerns, for example, going in camera. There are also issues around using private platforms from a privacy and security standpoint. Could you address those three issues?
I sure can. It depends on the case, Mr. Cooper, through you, Madam Chair. For appeals on questions of law, the open court process is actually enhanced by Zoom because more people can get access to a hearing before three judges of an appellate court or even the Supreme Court of Canada by Zoom. That's a wonderful, wonderful new form of technology in open court, and we should embrace it. But you're right, there are trials at the trial court level where there are real privacy concerns, where people are recording the testimony of witnesses even when they're told they can't, and it's an offense to do so. So how do we check that? How do we protect the witness who does not want to be identified? Even jurors, as we know in the George Floyd trial in the United States recently, were kept away from the general public in terms of them being able to be identified by those viewing the case. So everyone has an interest in an open court system, but particular cases do require the control that comes from in-person hearings, and it is case specific.
You've muted yourself, Mr. Cooper.
Okay, I think my time is just about to expire, but maybe just to the point of private platforms and the use of private platforms such as Zoom. What are your thoughts on that from a privacy and security standpoint?
Well, our courts in Ontario have fully embraced the Zoom technology, and it's working extremely well. Just because it's a concept of private-public sector partnerships in a way. It's a good platform from the private sector. It's been chosen over others, and the court was free to do that and dealt with it very thoughtfully and carefully before it embraced it.
Thank you. Thank you very much, Mr. Cooper. We'll now go to Mr. Virani for 5 minutes. Go ahead, sir.
Thank you, Madam Chair. I'm going to direct my questions to Mr. McCarthy. Welcome, Mr. McCarthy. Would you say when, in the context of addressing some of the issues that you've highlighted, that with respect to unrepresented accused, allowing court officials to assist them in administrative matters would be a step in the right direction? And secondly, with respect to preliminary inquiries, allowing an accused to appear by video in a preliminary inquiry and a trial on consent, including when evidence is taken, would be a step in the right direction.
Through you, Madam Chair, and thank you, Mr. Virani. Two very separate but important issues. I was a duty counsel in my younger days when you had per diem duty counsel. The presence of an individual that can assist and advocate not only helps the individual unrepresented litigant in family and criminal cases in particular, but it also assists the court to make sure that people are steered in the right direction. So that's a very important feature, and that's for the provinces to fund. And I think there's a place for volunteerism too among duty counsel. With respect to the second question, remind me again.
So it's about preliminary inquiries.
Yes.
And ensuring that an accused can appear by video in a preliminary inquiry and a trial on consent.
Right. So there are many who say maybe we have to end the preliminary inquiry because it's largely a discovery mechanism. But certainly in terms of being present before the court, because a preliminary inquiry really is just about hearing the evidence, maybe testing the evidence, sometimes getting a committal on a lesser offense, I submit that that's a very good and proper use of the accused not having to necessarily be there in person, but rather remotely, because it really is a discovery process. It's not whether his or her liberty is not truly at stake in a preliminary inquiry.
Right. And now I want to address some of the aspects of Jordan that you talked about at length with some of my other colleagues. So agreed, as a former litigator, that obviously judges are not infallible. That's fair. But the Jordan case, I feel like
don't tell him I said that.
Fair enough. You're appearing before them still. I'm not right now. But what I would say is that it appears that we're giving a bit of short shrift to the decision itself, because paragraphs 69 to 71 of the decision in Jordan talk about exceptions and extenuating situations, right? So it wasn't as if the judges crafted the rule to be ironclad. They indicated, and I'm going to read to you paragraph 71, which says at the end of it, it says, ultimately, the determination of whether circumstances are, quote, exceptional will depend on the trial judge's good sense and experience. The list is not closed. However, in general, exceptional circumstances fall under two categories: discrete events and particularly complex cases. To my mind, and I'm wondering what your opinion is, wouldn't the pandemic be considered an exceptional circumstance?
Yes, it is. And no doubt a judge applying Jordan and in its wise words that you've just quoted would perhaps use the fact of the COVID pandemic not to grant a stay. But remember, every time you deploy a judge to a criminal case to deal with anything, because it's in priority to all the other cases because of Jordan, you've just used judicial resources that can't be used in other types of cases where there aren't time limits. And so you're missing the point with respect. I'm saying a pause is necessary on this issue so that judicial resources are not deployed in priority to criminal cases at the expense of family, child protection, and civil cases. That's what's happening. We need a pause on the monopolization of our judges in the superior courts across the country because of the effect of the Jordan case. It's unintended consequences. They didn't foresee the pandemic coming. And you can't just deal with it on a case-by-case basis, because if you do, you're tying up judicial resources.
Okay, so
you're just compounding the problem.
I've just got a minute left here, but I'll confess to you that you asked for a conversation to take place, and conversations have already taken place. And some of what I put to you exists in Bill C-23. Some of those changes that I put to you at the start of my questioning, and C-23 is the product of conversations, and we don't have any instances of any provincial leaders or attorneys general asking the federal minister to invoke the notwithstanding clause. And you'll forgive me for being a bit thinking that maybe this is a bit ideological, because we know it's been used by certain governments, including by the government that in the province where I'm located. And I know you've been a candidate for the provincial Conservatives in Ontario and a candidate for the federal Conservatives. So is your interest in invoking the notwithstanding clause simply based on ideological perspectives?
Through you, Madam Chair, Mr. Vrani, not at all. I will be happy to report to you, I've been a candidate for the Conservative Party of Canada, but I've also voted for Liberal and NDP and Green candidates who I respect, who've run in my ridings. And so I'm nonpartisan on this. I come to you as a counsel and advocate before the court. I'm currently on the Rules Subcommittee on Experts for the Civil Justice Rules. So it's a plea for help for our courts.
Thank you very much, Mr. McCarthy. Thank you, Mr. Vrani. We'll now move on to Monsieur Fortin for 2.5 minutes, sir. Please go ahead.
Merci, Madame la Présidente.
Thank you, Madam Chair. Listen, Mr. McCarthy, I feel discriminated against because you didn't mention having already voted for the Bloc Québécois. So, that being said,
40 years, but I've never lived in a Quebec riding, Monsieur Fortin.
So
Sorry
sad.
about that. I would probably vote for you if I could, because I respect you very much.
Good. Monsieur
Mr. McCarthy, very quickly. I only have 2 minutes. Now, I understand this idea of a dialogue that you'd like to have so that we could put aside the Jordan decision during the crisis. I also understand my colleague's arguments, Mr. Virani. He's right. There are measures in place for exceptional cases and circumstances. But all of that being said, Mr. McCarthy, would you not agree with me that the problem of the reasonable time, well, it didn't start just a few years ago. It didn't even start with the Jordan decision. This goes way back, a number of years, a number of decades back, where there were problems with the time period. So wouldn't it be good to think of a new way of administering trials? For example, how about, we talk about plea bargaining, but how about mediation? Even in civil cases, wouldn't there be a way to make mediation mandatory, to introduce a mediation stage before a court even gives you a trial date? That would force people to talk. And what about nominating other judges? Wouldn't that allow for more sittings to happen at the same time? Wouldn't that help the situation with the reasonable time? I only have 1 minute left. I know it's awful. We could have talked about this all day. But in your opinion, are there other measures that, aside from Jordan, could help us get through this problem with the backlogs and delays?
Madam Chair, excellent question. And those measures have been implemented and are being embraced. In fact, the system would collapse without mediation and pretrials. But this is about the use of judicial resources in courts of general jurisdiction. Judges are being monopolized by criminal cases in the adjudication, even of these stay motions, at the expense of other very important cases in family, child protection, and civil justice. That's the problem. We're talking about in the court system, not the settlements that are reached because of these measures outside the court system. It's been widely embraced and it's working, but this is about judicial adjudication.
Yes, but when you say it's in place, mandatory mediation, correct me if I'm wrong, but that's not in place in Ontario. In Quebec, you do have to do a report. But there's no requirement. Is there one?
It's mandatory. Rule 24.1 of the Rules of Civil Procedure in Ontario.
Thank you very much. We'll stop there. Thank you, Monsieur Fortin. We'll now go to Mr. Garrison for 2.5 minutes. Go ahead, sir.
Thank you very much, Madam Chair. And I do want to return to this question of the Jordan decision and time limits. And I thank Mr. Virani for pointing out that there is still discussion for trial judges to decide what are exceptional circumstances. As we look down the road, though, I do always worry about the use of the notwithstanding clause and believe it should be used sparingly. And it would seem to me that the real long-term question here is the under-resourcing of the court system as a whole at the provincial level. And so if provinces were providing adequate resources, both in terms of the number of judges and all the associated court personnel that we need to make trials move forward, that we wouldn't have this problem with delays. And I'm interested in Mr. McCarthy's views on that.
Thank you, Mr. Garrison, through you, Madam Chair. Well, remember, I'm talking about Section 96 courts and Section 96 judges. They're appointed not by provincial governments, but by your government, right? That's first and foremost. And then the
positions are created by the provincial government and filled by the federal government. So the number of judges is up to the province, and the federal government then fills them, I believe is correct.
I respectfully disagree with you. The federal government has sole power to appoint or not appoint Section 96 judges and fill those vacancies. And sometimes they've been slow to do so, which causes a backlog in and of itself. But that's not what we're here to discuss today. The point is, yes, of course, a notwithstanding clause should be used sparingly, but it's got to the point where it's got such a bad name and there's partisan views on it. It is a legitimate constitutional tool. I encourage you to read Professor Hogg's comments on it. It's a unique Canadian instrument. And what it does is, in this case, temporarily ensures that judges are not monopolized with even having to deal with exceptional circumstances. They won't have to deal with these stay applications if this were invoked. That ties up their time. Whenever they have to have a hearing, remotely or otherwise, and make a decision, that is use of judicial resources. And that takes them away from other matters within their jurisdiction in that same court. That's the problem.
Okay, I thank you very much for bringing this issue before us. I think it is an important one for us to consider. And with that, I'll end my questions, Madam Chair.
Thank you very much.
Thank you very much, Mr. Garrison. We are now approaching the end of the hour, so I'll take this time to thank our witnesses for appearing before us today and then for your testimony. Anything that needs further clarification that has come out from the questioning, if you feel so inclined, please do provide us with written clarifications. We would appreciate that. You can do that by sending an email to the clerk. So thank you very much. We'll suspend temporarily as we let in our next panel. Thank you, everyone.
Thank you.
just say a few comments for the benefit of the new witnesses that have joined this panel. Welcome, first and foremost. Thank you for being here today. A few housekeeping rules. When you are not speaking, please make sure that you are on mute. And before speaking, please wait until I recognize you by name, and then you can unmute and speak. And once you're finished speaking, please make sure that you put yourself back on mute. A reminder that all comments should be addressed through the chair. And for all of you, interpretation is available at the bottom of your screen. You'll see a little globe icon that says interpretation. Select the language that you would like to listen to. You can speak in any language that you so choose, English or French. So with that, I'll welcome our guests here today. As an individual, we have Joshua Seeley Harrington, who is an incoming assistant professor at Lincoln Alexander School of Law, Ryerson University, and a lawyer at Power Law. We also have from the Criminal Lawyers Association of Ontario, Mr. John Struthers, who is the president, and Mr. Daniel Brown, who is the vice president. And then we have the Indigenous Bar Association of Canada, which is represented by Mr. Drew Lafont, who is the president. So to the witnesses, each of you will have 5 minutes to make your opening remarks per organization. I have a 1-minute time card and a 30-second time card to help you keep track of those 5 minutes. And we'll go ahead and get started with Mr. Seeley Harrington. Please go ahead. You have 5 minutes.
I want to begin by thanking the Standing Committee on Justice and Human Rights for inviting me to appear today to speak about the pandemic and the criminal justice system. I have only 5 minutes, so I'll cut straight to the point. In many ways, COVID-19 has not created new problems for criminal justice, but rather exacerbated existing ones. With this in mind, the state should not be making minor individual changes to respond to COVID-19. Rather, the state should be making major structural changes to respond to persistent systemic disadvantages and thus comply with constitutional obligations it has long neglected, particularly for Black, Indigenous, and low-income people. Specifically, to stem the tide of prosecutions overburdening our courts, I would urge this committee to prioritize not increasing investment in carceral institutions, but instead decreasing reliance on them. With respect to the prior witness, Mr. McCarthy, the just response to pervasive constitutional violation is not to license that violation with the notwithstanding clause, but rather to remedy it. And to be clear, there's nothing nonpartisan about thinking that the best response to a constitutional defect is to let it continue for 5 years. I will briefly discuss 2 key points to advance this thesis. 1, the problem, and 2, the solution. First, let's start with the problem. It is not COVID-19, and the Canadian government concedes as much in this year's budget. 2 examples, drugs and safety, are illustrative. With respect to drugs, the Canadian government recognizes that the opioid epidemic was worsening since before the pandemic began, and that the pandemic simply compounded the ongoing opioid overdose crisis in Canada. And with respect to safety, the Canadian government recognizes that crime has root causes independent of COVID-19. True, pandemic-related job losses and financial stresses have increased rates of, for instance, gender-based violence, but these structural conditions are not unique to the pandemic. Indeed, the government is well aware that access to jobs, education, and stable housing make communities safer by helping to end the cycle of crime. So what solutions should the government consider? Again, drugs and safety are illustrative. With respect to drugs, the government has declared that it's taking a public health-centered approach to addiction. Yet, it persists in criminalizing simple drug possession. This is incoherent. As activists in community with the vulnerable and racialized populations impacted by punitive drug policy explain, decriminalization is urgently needed, especially for a government that purports to be committed to fighting systemic racism. And with respect to safety, the government's response overemphasizes increasing prosecutorial capacity and a well-funded police service with improved training processes. But how does policing respond to the root causes and structural conditions the government itself knows lie at the origin of crime? Those conditions cannot be addressed without significant investment. and investment means freeing up government money. For this reason, myriad community organizations have united in calling for defunding police, dismantling carceral institutions, and building alternative systems that focus on the very conditions the government itself acknowledges contribute to crime, for example, housing, health, and education. If, as the government concedes, the aftermath of gender-based violence costs Canadians billions annually, then actually addressing the conditions that lead to that violence, even if it demands unprecedented public investment, is ultimately prudent fiscal policy. To be clear, the policy positions that I am describing are not unrelated to criminal justice trials and court delays. Rather, they are foundational to them. For instance, to reduce court delays, the government plans to add 13 new superior court positions. This will not work. One reporter recently described court staff as being totally overwhelmed and overworked, with scheduled hearings not proceeding and vulnerable justice system participants left in profound confusion. And in my understanding, simple two-day trials are currently being booked into March of next year. The system is, without question, overwhelmed. The pipe is bursting, and we cannot fix it by frantically taping over holes as they inevitably appear. Rather, we need to turn off the source. And that means systemic reforms, including ceasing policing and prosecution of administration of justice offenses and drug possession. In sum, if this committee wants to decrease delays in the criminal justice system, a crisis long predating the pandemic, it must decrease criminalization, policing, and prosecution. Other modest tweaks will simply not do. And the longer this government delays in implementing such changes, the longer justice will be denied to everyone, both victims and accused alike. Thank you.
Thank you very much, Mr. Seely-Harrington. We'll now go to the Criminal Lawyers Association of Ontario. You have 5 minutes between you. Please go ahead.
Good afternoon, Madam Chair, Vice Chairs, and honorable members. Criminal cases are more complex and consume greater court resources than ever before. We all know that lengthy court delays can violate an accused person's constitutionally protected right to a trial in a reasonable amount of time and lead to charges being stayed. Ongoing and repeated delays in the court system caused by the COVID-19 pandemic can also diminish the public's confidence in the criminal justice system, which is fundamental to its operation. The answer isn't to give up and to ignore constitutionally protected rights, as advocated by Mr. McCarthy in the last panel. The Criminal Lawyers Association believes that the answer to COVID-related backlogs in the court system is to enact policy changes that will ensure the system has both time and resources to focus on the most serious cases and those that just simply can't be solved without a trial. In our time here, we'll focus on 3 suggestions that will help remove cases that are clogging up the court system, but shouldn't be. Number 1, to remove barriers to resolving cases without a trial. Number 2, to divert administration of justice offenses out of the court system. And 3, to decriminalize drug possession offenses. The decision about whether or not an accused person should proceed to trial can be heavily influenced by the sentencing consequences of a particular crime. A person's far less likely to plead guilty if there's consequences that impact their immigration, their employment, or will simply incarcerate them for a long period of time. And these significant consequences act as barriers to solving cases without trials. One of these barriers are mandatory minimum sentences. And I mean mandatory minimum jail sentences, but mandatory minimum consequences that flow from certain criminal convictions. Drinking and driving convictions, for example, require the sentencing judge to impose a mandatory criminal record in every single case, even for a first offender who's barely over the legal drinking limits. These otherwise resolvable cases are clogging up the courts, and it's no coincidence that drinking and driving offenses are one of the most litigated categories of cases, and one of the offenses that frequently breaches the delay ceiling set by the Supreme Court in the Jordan decision. Eliminating mandatory sentences would drastically reduce the number of cases that go to trial, which would in turn ensure timely justice for other cases in the system. Another barrier to resolving cases is the 5 to 10 year waiting period a person with a criminal conviction must endure to have their criminal record cleared through the record suspension process. Now, the proposed changes in Bill C-22, introduced by this government, addresses some of these barriers, including the elimination of some mandatory minimum sentences, but fails to address other ones like the drinking and driving mandatory convictions. Bill C-22 also fails to address the barriers to obtaining record suspensions, including the prohibitive costs and lengthy wait times. Another way we can reduce backlogs in the court system is to divert administration of justice offenses from the system altogether. These offenses, including failing to appear in court and failing to comply with a court order, account for more than 1 in 5 cases right now in our justice system. Now, following Senate recommendations in 2017, the government changed the criminal code to include a process whereby the police or the prosecutors can now opt not to charge somebody and opt not to prosecute them for one of these offenses. And instead, they could refer them to a judicial referral hearing where a judge would potentially tweak the bail release plan or decide to reincarcerate the person. But what this regime avoids is piling on criminal charges, which come with their own requirements for disclosure, meeting with the prosecutor, guilty pleas, trials, and sentencings. Unfortunately, these diversion tools simply aren't being utilized by the crowns of the police, who must initiate the referral hearing process. So this new regime, designed to reduce some 175,000 cases in our system, is lying dormant. The solution here is simple. Remove those barriers that prevent either a judge from referring a case or by placing discretion completely in the hands of the police or the crowns. A similar concern exists with the increased discretion afforded to prosecuting low-level drug offenses. Bill C-22 goes some way towards decriminalizing these offenses by encouraging prosecutors to divert some drug cases out of the system in favor of drug treatment programs. But placing discretion to divert these charges entirely in the hands of the prosecutors and the police creates obvious problems. For example, will they use this discretion? We're also concerned about whether this discretion will be applied equitably. We know that discrimination and bias runs rampant through the justice system, adversely impacting Indigenous and Black defendants far more than any other race. And if we accept that drug addiction is a public health issue and not a criminal law issue, we shouldn't be prosecuting these cases at all. In conclusion, removing barriers to guilty plea resolutions and diverting drugs and access to justice offenses from the justice system will free up precious court time and resources that can be redeployed to other cases in danger of being tossed for unreasonable delay following the COVID-19 pandemic, and ensure timely justice for victims and accused persons.
Thank you. Thank you very much, Mr. Brown. We'll now go to Mr. Lafond. Mr. Lafond, I know that you have your headphones are downstairs in your reception, but maybe if you can try to speak loudly and slowly to ensure that that we get the best interpretation possible. Perhaps you can send somebody downstairs to pick them up, so at least with the question answer we can at least capture your voice as much as we can. But please go ahead. You have 5 minutes to make your opening remarks. Mr. Lafond? Mr. Lafond, are you able to hear me?
Yeah, I can hear you. Can you hear me at the committee level?
Yes, if you can speak just a little bit louder, we should make do, and hopefully you can send somebody to pick up the headset from the reception of your building downstairs.
Okay, absolutely. I'll work on that. So thank you for the invitation today. Mitone mio kitsepao dakio nitsonega guana dotamak miwa senata ahayek mitoni kitnagno skumtano dakio asimno betagoteg. My name is Drew Lafond. I'm here on behalf of the Indigenous Bar Association. I'm serving currently as the president, second of a 2-year term. The IBA is a national not-for-profit organization comprised of Indigenous lawyers, judges, law students, and academics.
I'm so sorry, Mr. Lafond. There seems to be some kind of an interruption in your sound that's coming. Maybe we should then just wait for your headset to arrive before you make your opening statements.
Okay.
In the meantime, would members feel comfortable if we went into the round of questions, or do we want to wait for Mr. Lafond's opening statement? Yes, Mr. Moore.
Well, just to say, Madam Chair, I could hear Mr. Lafond perfectly, before he put the earbuds in. I don't know if that's going to make any difference, but I could hear him perfectly earlier, but then he was asked to put earbuds in, and now it's, as you said, it's very difficult, but I don't know if that's worth trying so we can hear the testimony before questions and answers.
The challenge, Mr. Moore, is the interpretation, just so that members have access to that interpretation to French. That is the main issue. But Mr. Lafond, if you wanted to perhaps try again without your headphones, maybe we can do that.
Good morning, and can you hear me now?
If you can speak a little bit louder, that would be great.
Hello, can you hear me this morning? Is this loud enough?
Yes, and I'm just going to pause you and go to Monsieur Fortin. Monsieur Fortin, are you getting any translation? Are you able to understand the witness?
Oui, j'entends la transcription en français. Je comprends qu'on n'a pas le texte non plus là, du témoin, là, ses notes écrites. I
don't understand why we don't have his text. That could have at least been useful. But in any case, go ahead, Madam Chair, with what you think. I think we should start with the other witnesses, as you suggested. That might be easier.
Okay. Thank you, Mr. Fortin. So perhaps we'll go into our first round of questions as we wait for Mr. Lafond's headset, and then once it's arrived, we'll give him his 5 minutes and then get back into the questions. So we'll start with Mr. Lewis for 6 minutes. Go ahead, Mr. Lewis.
Thank you, Madam Chair. Certainly appreciate it. My first question will be for Mr. Brown. Sir, you spoke a lot about backlogs within the justice system and that type of processing, and obviously we've we got quite a case in our hands with regard to a lot of people getting fined. So when I speak to that, I'm talking about people that are coming in on planes to our airports that I've just said, you know what, I'm not even going to bother going to do a 14-day quarantine. Just give me that fine. People come across our borders. I'm not going to quarantine. Just give me that fine. And so there's going to be an extreme amount of backlog with regard to what the courts are going to face here, because people are, quite frankly, are not going to pay it. So I'm wondering, could you comment on really where is this going to go? Are the courts just going to throw these cases out? I know you were speaking a lot about drinking and driving cases, and I respect that, but I'd like to go down a different path, because truthfully, I believe the court system is going to be stretched to stretched to the limits. And I'm just curious if you could comment on what does this look like? What does it look like going forward? I believe you had mentioned the courts are looking into March of next year. Potentially, we could talk about March of 2025. So what happens in that circumstance?
Sorry, thank you. Via Madam Chair, Mr. Lewis, what I can say is that the courts don't just have this ceiling that once it's breached, it's an automatic violation of somebody's charter rights. What we have is we have to look at the reason why the ceiling was breached. So if a case takes too long, we look at why it took too long. And as Mr. Varandi said in the last panel, the court discount what exceptional circumstances or discrete exceptional events. So things like the pandemic are simply subtracted from the delay assessment. It's as if no delay occurred, where the delay that has happened because the court's been shut down are attributable to the COVID-19 pandemic. So I suppose we can assume, as you are, that everyone is going to fight their case or everyone goes to trial. I mean, we simply know that isn't the case. We know that some people will go to trial, and some of these offenses aren't the types that would clog up the criminal court system. They're what we call provincial offenses. They're the types of things like traffic tickets, parking tickets. Again, the sky isn't falling here, what we have is a situation where the courts have come up with some great ideas to remedy these problems in the short term. And we've offered to you some solutions in the long term, finding ways to get some of these cases that just don't need to be there out of the court system. And there's lots of other solutions to come up with, but I don't think we need to worry about simply having these fines being simply dismissed because they've taken too long to come to trial. I think the courts are going to account for the delay and the reasons behind the delay in assessing whether or not any of these cases should be thrown out or simply dismissed.
Thank you, Mr. Brown. Through you, Madam Chair, so back to Mr. Brown again. So you had mentioned about federal and provincial, and herein lies the issue that I see in that our borders, our airports, our borders, international airports, that's very, very federal. And the provincial system, in the event that they get a ticket, quote unquote, is that going to land on the laps of the provincial legislation, jurisdiction, or will that be federal jurisdiction?
Well, sorry, through Madam Chair, Mr. Lewis, it really depends on who's initiating the offense in the first place. If it's the province that's enacting some sort of bylaw infraction, that's going to end up in the provincial system. And if it's some sort of piece of federal legislation that's being violated, that's going to be part of the essentially the criminal system, in the same way that drug offenses or other offenses are prosecuted. And so either way, I mean, it's the same judges that are likely going to deal with these problems, or so we have to be prepared for it. We have to acknowledge that these issues may come through. But again, I don't think the solution is simply to, as some panelists have suggested, is just to suspend somebody's constitutional rights indefinitely to accommodate for the ability to prosecute some of these fines. I think the answer is to look at, well, what else can we do to relieve the burden off the justice system? Because we know that it's going to be a tragic situation if a victim of a crime has to wait years and years and years for a case to make their way through the justice system. Likewise, an accused person who's facing strict bail restrictions or is in custody. I mean, we can't have a situation where we just allow those cases to go on indefinitely. We have to find other solutions.
Thank you, Mr. Brown. Last question. Madam Chair, through you to Mr. Brown again. Sorry to pick on you, sir, but I'm not trying to pick on you. I really respect, and I was listening to your testimony very, very in depth. The federal government has introduced Bill C-23 to try and address some of the backlog. Do you have any other thoughts or feedback on the legislation as it was introduced?
Yeah, I'm going to pass this one off to my colleague, Mr. Struthers, and I'm sure he'll have some things to say just about the importance of Zoom trials and the ability to accommodate those trials.
Madam Chair, if I may, our Zoom trials have been actually a godsend. The system would have failed completely without them, and we've done very, very well for the past 13, 14 months now, having an awful lot of things done by Zoom. But your question about the airports and courts and the interrelationship of those two things, look, the problem in the courts isn't a series of rich scofflaws taking $3,000 tickets at the airport because they want to go home. This is not the problem. And, deflecting to suggest that the problem with COVID or the problem with the justice system is, a federal problem with the airport is frankly complete nonsense, with the greatest of respect, sir. This is not the issue. If there are 4 people in Canada that took a $3,000 ticket in the past 12 months to enter Canada and say, to heck with you, I'm not going into my quarantine, I can afford $3,000. If you can find those 4 people, I'd be amazed. This is not the issue. So with the greatest respect, what we have now, and what Mr. Seeley-Harrington was very clear to point out, you don't lose weight just by exercising. You have to lose weight by eating less. You have to digest less, which means that what we have is an entire system that is criminalizing mental health, criminalizing poverty, criminalizing domestic problems, and criminalizing drug addiction, and expecting the criminal justice system to solve all of these social problems. It can't do that.
I'm going to stop you there, Mr. Struthers. My apologies. We're well over time.
Thank you, Madam Chair.
Thank you, Mr. Lewis.
And to Mr. Struthers, I will, 4 is an understatement. Thank you, Mr. Struthers. Thank you, Madam Chair.
Thank you. So I noticed that Mr. Lafond has his headset now on his head, which is wonderful to see. So Mr. Lafond, if you would like to make your 5 minutes opening remarks, please go ahead and do so now. We can't hear you. Just make sure that that your that your headset is selected as your audio, please, on your computer.
Can you hear me now?
Yes, absolutely.
There you go. Thank you for the invitation and apologies for the delays, everybody, and thank you kindly for your patience. Mitone mio geksepa gakio natsoneke guana dotamak miwasen e hayaeke mitone gakio ginaskumtinoel. My name is Drew LaFond. I'm here as the president of the Indigenous Bar Association. I've been serving as the president, second of a 2-year term. The IBA, by way of background, is a not-for-profit organization comprised of Indigenous lawyers, judges, academics, and students across Canada. Our mandate generally is to promote the advancement of legal and social justice for Indigenous peoples in Canada and the development of laws and policies that affect Indigenous people generally. In response to the request by the committee for submissions, the past year has been rife with examples about territorial sovereignty, broken treaty promises between the Crown and Indigenous peoples, and more shockingly, the disvalue of Indigenous lives, particularly the lives of Indigenous women and youth. And the COVID pandemic is worsening the underlying legal, political, health, economic, and social injustices that Indigenous peoples and communities face. And against this backdrop, the IBA is acutely concerned with the treatment of Indigenous peoples and the recognition and respect of their human rights. The IBA responded to the events in the last year by finding some pragmatic and timely responses to the rapidly changing political, economic, and social realities facing Indigenous peoples. So the first initiative we undertook was in April of 2020, where we partnered with researchers at the Department of Indigenous Studies at the University of Saskatchewan to conduct an online survey that examined the legal impacts of COVID-19 and the ability of the legal profession to respond to those impacts. And as part of that study, the participants spoke about primarily jurisdictional issues that they were facing. So conflicts over who has the authority to regulate who's coming into Indigenous communities, who has the authority to, in relation to a community's pandemic and health response, the exacerbation of jurisdictional issues that were happening prior to the pandemic, including state undermining Indigenous laws and legal authorities. There were participants who expressed concerns regarding consultation and negotiations where existing agreements and precedents meant to uphold Indigenous rights are too often being ignored in the interest of economic revitalization plans. And there were concerns raised about the case delays, which have worsened and already slow processes and deferred Indigenous rights matters further. And these delays are uneven, with Indigenous clients having to wait for access to the courts while resource extraction approvals by the Crown continue at a regular and accelerated pace. We must address the clear gendered issues in relation to the COVID-19 pandemic, including increased family violence, disproportionate family care responsibilities faced by Indigenous women, access to safe and stable housing, gendered violence outside of the home, concerns about industry or man camps posing dangers to the health and safety of nearby Indigenous communities, and worsening economic inequalities for Indigenous women. So these gender-specific injustices create barriers to Indigenous women enforcing their rights and accessing meaningful legal participation. Second, the IBA worked with the UBC Faculty of Law, the UBC Indian Chiefs, or Union of BC Indian Chiefs, the BC First Nations Justice Council, the Nuu-chah-nulth Tribal Council, and the First Nations or Indigenous Legal Clinic in BC to study 21 reports in the last 30 years concerning Indigenous peoples in the justice system. And as a result of that study, we pulled some 10 recommendations for immediate action, which I'll mention briefly here. Create a national Indigenous-led police oversight body, establish a national protocol for police investigations, redirect public safety funding to services that increase community safety, implement a multi-pronged Indigenous de-escalation strategy, establish a national protocol for police engagement with Indigenous peoples, amend Canadian and provincial territorial human rights codes to include Indigenous identity as a protected ground against discrimination, create Indigenous courts, increase Indigenous representation across all levels of the criminal justice system, establish requirements that judges give written reasons in all Indigenous sentencing cases, and require that judges give written reasons in all Indigenous child apprehension cases where a child is placed outside of the Indigenous community. Just to close off, during the COVID-19 pandemic, we're facing significant challenges in being able to center our well-being and our legal rights, including our rights to health, access to our territories, to our laws, and to self-determination. Canada has fiduciary obligation to support the enforcement of rights, protections for Indigenous peoples. those are my submissions to the committee today, and thank you.
Thank you very much, Mr. Lafond. Your sound was coming through quite clearly. We appreciate that. We'll resume our questioning. We'll go to Madame Briere for 6 minutes. Please go ahead.
Thank you, Madam Chair, and thank you to all our witnesses. I appreciate your expertise. My question is for Mr. Sealy Harrington. Vous avez dit dans votre introduction que la COVID avait...
You said in your introduction that COVID had not created new problems, but rather compounded existing problems. Do you think that strengthening the uses for alternatives, dispute settlement options like mediation would be good opportunities to use?
Madam Chair, I think that alternative systems like mediation can be part of holistic approaches to dispute resolution with a view to addressing things through a lens of efficiency. But I do want to reaffirm the idea that something like mediation falls towards the kind of tweaks that I want to caution the committee against, insofar as, you know, multiple people who have spoken today have described the extent to which the system is completely and in many ways catastrophically overwhelmed. I don't know that adding or increasing avenues towards mediation is a proportional response that will be able to comply with the constitutional obligations at play. And so I would say that while that could be one of various tools that could be added, it would fall short, I strongly suspect, of the systemic change needed to bring dispute resolution within Canada back under constitutionally required thresholds.
Thank you. Merci.
Thank you. Now, as for sexual assault, domestic violence, we heard through a study of another file that the idea of an integrated tribunal could be a good solution. I'd like to know what you think about this idea. It would be an integrated tribunal, so the victim would not have to repeat at various levels their whole story. Everything would be heard within one system.
Madam Chair, I haven't done a lot of study on integrated sexual violence courts. I do think that alternatives to the kind of existing pervasive and highly punitive approach to addressing sexual violence is ineffective. And I think it's ineffective both for accused and for victims for various reasons, including some that Ms. Briere mentioned. So again, I think I would respond to this in a similar way to the idea of mediation, not identically, but similar. I think that when we're trying to deal with the systemic problems that I've described and that others have described, I think that increasing mediation or creating a parallel court when we're trying to deal with a variety of cases that are pushing us well beyond our limits, I don't think are responses that will effectively address that problem. So I won't say that integrated courts are something that I would per se oppose, and I haven't studied them extensively, but I will say that creating a parallel court system without removing the gigantic amount of input that goes through the criminal punishment system as a means of dispute resolution, I strongly suspect will not address the core issue here today, which is delays. I think that the committee needs to strongly consider reducing the inputs into the criminal punishment system if delays are its concern.
Alors, vous avez parlé d'encore.
Now, you talked about structural changes in your remarks. Do you have examples that could give us some more ideas and insights?
Absolutely. Decriminalization of drug possession, dropping of mandatory minimum sentences, as Mr. Brown mentioned, and the impact that has on the resolution of disputes. And I think more fundamentally, as I raised in my remarks, the government itself in its budget admits and describes the various ways in which the conditions of people in society, of low-income people, of racialized people, is foundational to cycles of criminality. And the government spends a lot of money on criminal punishment, on policing, on prosecutions, on incarceration. These are not cheap fixes, and the government, and money is fungible. So I would stress that if the goal is decreasing crime and decreasing delays, that meaningful and substantial, perhaps even unprecedented investment in communities, which I'm happy to hear some other witnesses echoing in their remarks, I think is an actual approach that will engage with the root causes of crime. There's certain labels that come up in the government's budget: root causes, systemic racism. I would urge the committee to take those terms seriously, to not refer to them performatively, but to think about the ways in which significant change as to how we approach public safety within Canada is urgently needed if we actually want to decrease delays. I think the ideas that you're proposing may work in certain ways to kind of tweak the system, but I would encourage the committee to think more broadly in terms of how we approach public safety in Canada.
Thank you very much. Time for another question, Madam
5
Chair?
seconds.
No. Oh, okay, then it's okay.
Thank you. Thank you, Madame Briard. We'll now go to Monsieur Fortin for 6 minutes. Go ahead, sir.
Merci, Madame la Présidente.
Thank you, Madam Chair. Thank you to the witnesses who are here. I appreciated each of your remarks. But Mr. Struthers, what you said particularly struck me. I liked your analogy when you said getting thinner doesn't mean just doing exercise, but eating less. I think this is something we should keep in mind. But that being said, at the substance of this, the lesson we should take from this, well, I'm wondering about it, and I'm thinking, is our legal system, justice system, currently paralyzed and managing files poorly, or is it just underfunded? And so is it not more us, the legislators? Well, maybe we're asking the legal system to eat a little too much, and there are a number of offenses, and the situation wasn't always like that. Now, I also like what Mr. Brown said. And it was very coherent. You talked about barriers that currently hinder the ability for some cases to be dealt with outside of the courts. Now, I was wondering, would it be possible, first, Mr. Brown, to have a copy of your notes, because it was very interesting. And then, Mr. Struthers, I'd like to hear you speak a little more on this matter of what explains all of the clogging in the system. Okay, eating less and exercising, but are we asking them to do too much, or is the system not being fed sufficiently? So I'd like to hear you talk about that, please.
Very much for the opportunity to speak about it. The problem is this. We have a whole bunch of societal problems, and we've decided that they are going to be dealt with by policing. We're going to arrest our way out of the problem of mental health. We're going to arrest our way out of the problem of drug addiction, arrest our way out of the problem of poverty. And this is never going to work. Our resources are being thrown heavily into issues that are not going to be resolved by the criminal justice system. You know, addiction and mental health are strongly related, but let's just look at what we're doing. By criminalizing drugs right now, let's take a comparison to alcohol. Let's say that you knew that 1 out of 10 bottles of wine was going to kill you, and yet the government insisted that all the labels be removed from the wine bottles, because that's what's happening on the street of Vancouver right now. These are not, if you will, overdoses. They're poisonings. People aren't deliberately overdosing. They're taking things they don't know what they are because there's no label. So we have a whole bunch of problems that we are throwing into the criminal justice system. Instead of investing in poverty or in mental health or in addiction, we're investing in the criminal justice system where we're caging people. You know, there's a new regime thinking about the way we look at these things. That's trauma-based evidence. Most of the people in the criminal justice system have suffered trauma in their lives one way or the other. The fact is. And so what we're doing is we're inflicting more trauma on them. Can you imagine taking someone with a serious mental health problem and thinking the solution is to put them in solitary confinement in a jail? This will not work. We have to divert things from the criminal justice system. And as Mr. Brown said, the barriers have to be removed very quickly. The thing people want to avoid is a criminal record. you know, they're not avoiding the counseling, they're not avoiding the stay away, they're not avoiding the don't have a weapon. They're avoiding the criminal record because it prevents them from working, from going on a school trip with their kids, from traveling to the States. They don't want the record. So if there was a way to do all of this work up front, be it probation, counseling, whatever it is, and then to have the charge dismissed, as they do in many American states, we would resolve a lot more. So there are solutions out there. We need to have less in the system, and we need to make it easier to get out of the system. Otherwise, we are going to have way too much to deal with for a very long time. Thank you, Madam Chair.
C'est intéressant.
Very interesting. And I understand that you're with the Criminal Lawyers Association of Ontario. Perhaps you have, you have some experience in private practice. In civil law, there's also backlogs. And as the previous witness explained, some people are communicating. And, well, with the Jordan, because of the Jordan decision, judges have to leave behind civil matters to go deal with criminal matters. And so those two are interconnected. Now, you talked about a criminal trial context. Now, I understand, I think it makes sense that we should consider those matters, but there are also barriers of the same nature in civil law. So would you be able to talk to us about that? What is preventing files or matters being dealt with in the civil law?
I'm not a civil lawyer, and I have made a clear decision in my life never to go near civil files because they last 6 and 8 years. The civil system is a complete mess. But I do not agree with the premise that people in custody, in jail, waiting for their trials, do not take priority over people arguing about money. Those people can go into a room and argue about money all day, but the people who are in jail have to have priority because it is a human rights issue. Thank you very much, Madam.
Je suis d'accord avec vous, Monsieur Struter, mais je me demande.
I agree with you, Mr. Struthers, but I was just wondering if you had ideas about the barriers that are preventing civil files from being settled. Mr. Brown, perhaps one last word because we just have a few seconds left. Would it be possible to have a copy of your testimony?
Merci.
Yes.
Thank you.
What I'd say is also, I've touched on a few points here, a few barriers. There are other ones as well. The unavailability right now of conditional sentences for many offenses, like fraud offenses. I know that's something the government is trying to reintroduce again in Bill C-22, but it is something where there's an absence of legislation to address a lot of these challenges. Also, the fact that right now, when somebody is found guilty of a fairly serious criminal offense, they're automatically deported without any right of appeal. And so there are so many reasons why people refuse to solve their cases and hang around the justice system and hang around and go all the way to trial and wait to see if their case gets thrown out for delay, because there's just simply no way to solve these cases in advance. And we need to find other opportunities to solve cases, remove those barriers. And if we're continuing to eat the same amount, we have to figure out at least a way to get rid of these cases that are in the system so that we can make room for these other cases.
Thank you.
Merci à chacun de vous.
Thank you, each of you.
I will.
Thank you, Mr. Fortin.
Mr. Garrison, for 6 minutes. Please go ahead.
Thank you very much, Madam Chair, and I'm going to resist the temptation to use my entire 6 minutes to applaud this panel. I think it's very important that they directed our attention to the root causes of delays in the system and the importance of protecting constitutional rights. We will have opportunities in Parliament to discuss other bills that deal with some of these questions, and I hope that we will see these witnesses back to give us further input on Bill C-22 and C-23. So I want to take the time today to talk about one of my concerns is that our shift to the Zoom platforms during COVID, while necessary in an emergency, may make some fundamental changes in our justice system, which I believe will disadvantage Indigenous people, which will disadvantage racialized Canadians and those who live in poverty. And so I'd like to hear from each of the witnesses on what they think about this shift of platforms and its impact on those who are most marginalized in the justice system already. And maybe we'll start with Mr. Seeley-Harrington.
Madam Chair, what I would say in response to concerns about shifting to digital forms of dispute resolution primarily would be that it's integral to the committee to adopt a systemic lens in terms of how it vets different digital options. And what I mean by that is I'm thrilled to hear Mr. Garrison reference concerns about systemic disparities, about the ways in which different procedural paradigms can have a disparate impact on different groups. I think that's true. To be frank, you know, I haven't been running trials during COVID, and so digital or otherwise. And so in that sense, I would defer to the Criminal Lawyers Association in terms of their perspective on the consequences of this for disparate groups. I could see circumstances where it's very important and other circumstances where it has negative consequences. And so I think what the contribution I can make to this conversation is to say that it is foundational to not only be thinking about procedure and what works and what seems fair in an abstract sense, but the material consequences. You know, an earlier individual during this meeting spoke about how one of the benefits of logistical complexities with certain hearings is that it pressures people towards settlement. I would say a systemic lens would raise concerns about that. If there's pressure towards settlement because of financial limitations, that's a systemically racist policy, full stop. And so I think that systemic lens is very important. But in terms of specific procedural ideas, I would defer to the other witnesses who would have more personal experience with that.
Thank you very much. Let's turn then to Mr. Struthers and Mr. Brown. Maybe you two can decide who wants to go first.
I'll go first if I could. I've done multiple Zoom matters, everything from peace bonds to murder prelims over the past year. Very serious cases, sex assault cases. I did one case where I was the only person on Zoom, everybody else was in the courtroom. The problem isn't the technology, it's a tool. And used properly, it can be used very, very well. You know, counsel can now appear in Attawapiskat where they couldn't otherwise on a Tuesday because it would take them 3 days to get there and get home. But here's the problem. We have a charter right to retain and instruct counsel. The retained part seems to have gone sideways because we have an enormous number of self-represented litigants, both in civil cases and in criminal cases. And the problem isn't really what technology you use. You know, impoverished people may not have MacBook Pros to come to court on. That, of course, is a very serious issue. But the most serious issue is they don't have a lawyer. Legal aid has been so dramatically cut in Ontario by 1/3 and not topped up by the federal government, particularly, as you know, not in the criminal context for many years, that we have thousands and thousands of people who are self-represented in the system. This is enormously problematic for delay. And if you're trying to speed things up, believe it or not, there are some circumstances where lawyers are actually helpful. And one of them is in the criminal justice system, because if you don't know what you're doing, it's going to take much, much longer. And of course, the judge has to effectively become your surrogate lawyer by explaining every step of the procedure, every step of the way, and all of the evidence has to be presented because, you know, you're not effectively able to admit it. So legal aid is a critical issue, much more critical than whether or not you're appearing in person or on Zoom or on Teams or whatever format you want to use. So
thank you very much for that, Mr. Struthers. Because I'm afraid of running out of time, I want to turn to Mr. Lafond. And first of all, ask him if he would table with the committee the report from the Indigenous Bar Association, because I think it would be very useful for this study and other work that we're doing. And then also ask him the same question about this shift to digital platforms and its impact on the people that he represents.
You're on mute, sir.
The Indigenous Bar Association be happy to table the report back with the committee when it becomes available. We're currently working with the University of Saskatchewan to get all of our ethics approvals in place and to finalize the drafts. The report itself is subject to a SSHRC grant, so there's some administrative hoops that we need to jump through before we can finalize it and get the sign off for it. But upon completion, we'd be happy to share the results of the report with you guys. When it comes to the issue of virtual representation in communities, the IBA had the opportunity to meet with the staff of the Justice Minister's Department, and we had raised with them the possibility of discussing the 21 reports that have been published in the last 30 years outlining the difficulties that Indigenous peoples face with the justice system. Substantively, I think this isn't an area that's brand new. This is something, the relationship between Indigenous peoples and the justice system is probably one of the most extensively and heavily studied topics in Canada right now. it's not a matter of actually going back and getting more commissions at this point. It's a matter of implementation, and that's where we got our recommendations from. So again, 10 recommendations that we want to see implemented in the immediate future. Now, the problem that we had with respect to the discussion about virtual representation in communities was that this was raised during discussions that we had with the minister's staff about the increase of digital platforms and what that was going to mean for Indigenous peoples. And
apologies, Mr. Lafond. We're really running low on time. If I can please ask that perhaps you can provide a written response to the remainder, that would be helpful to the committee. We'll now go into our second round of questions with Mr. Moore for 5 minutes. Go ahead.
Okay, thanks, Madam Chair, and thank you to our witnesses for appearing today. We're studying the impact of COVID on the justice system, and I know some of what we've talked about today deals with matters that pre-existed COVID. I guess I'm looking specifically, we heard this week from earlier panelists about how courts in a high pressure situation have had to adapt in much the same way we as parliamentarians had to adapt, and we're conducting this meeting today by Zoom, where in the past that was something that just didn't happen. So maybe to Mr. Brown, your association, for what you're hearing from your members, if there was one thing that's come out of COVID specifically that you would say, in the future, we should keep this, and this is solid and it's something that should be built upon. And then if there's an aspect of of our current situation that you think we should abandon, specifically on the response to COVID, for either of those, what comes to mind for you?
Thank you, Madam Chair, Vice Chair. COVID really has been a blessing in some ways when it comes to the technological advances of our justice system. The fact that we can now file documentation digitally, the fact that we can conduct court appearances digitally, that we don't need to drive to court to pick up evidence or evidence packages that now can all be produced digitally. These are great time-saving functions. They're making the justice system more efficient. They're reducing the number of court appearances that need to take place. And so this should all be encouraged. What we don't want is a system where there's absolute rigidity when it comes to how we make our court appearances. So we don't want a situation where every trial is mandated to proceed by Zoom or every witness must appear remotely. There are some cases where that works perfectly fine, and other cases where that harms the administration of justice, where in order to make full answer and defense, we need the witnesses in the room. And so to the extent that we can manage public safety, to the extent that we can manage available court resources, we also want to be able to maintain that option because, as I said, with that greater flexibility, we can allow for opportunities to utilize this technology and reduce delay, but also to ensure fairness in the process.
Okay, thank you. Mr. Lafond, thank you for your presentation today. For your membership as well, we did hear concerns about the downward pressure of dealing with criminal cases and then the fallout for some very important cases like family law matters and how delays there are problematic as well. What do you see as, what are some of the major concerns we have when justice is delayed, whether it's in the criminal or the civil context? Because I think I recognize there was a problem with the system before COVID. We've managed to have some developments that have helped with efficiency, but maybe you could speak specifically to delays in the system, whether it be criminal or civil, and how that impacts. And maybe same question to you. Is there something that's come out of COVID that you would like to see courts and the system maintain?
Mr. Lafond, you're on mute.
Yes, and falling short of calling COVID a blessing, I think it's been catastrophic on a lot of the Indigenous communities, and it's been horrific. The results have been horrific on our populations. Mortality has increased, and the access to health services has been extraordinarily frustrating and slow. And the ability of our elders to recover from this is going to be, the long-term effects have yet to be seen. When it comes to your specific question regarding the delays to the justice system, now this wasn't actually a point that was heavily emphasized in our report that we had conducted with the University of Saskatchewan. Again, going back to my presentation, the participants in the survey spoke largely about jurisdictional issues. So the questions and their focus wasn't heavily on the delays, although they noted that delays to the justice system exacerbated some existing procedural issues that had been identified in previous reports and commissions. The real issue was that this needs to be seen as an opportunity to fundamentally and systemically restructure the justice system in ways that we've identified earlier today, and in ways that we've identified in our correspondence to the Justice Minister David Lamedte's office on numerous occasions. Thank you.
Thanks very much. We'll now go to Ms. Damoff for 5 minutes. Go ahead.
Thank you, Chair, and it is an absolute pleasure to join this committee today. Mr. Brown, you mentioned record suspensions, and I couldn't agree with you more. It's something that I was really pleased to see in the budget to deal with those mean-spirited increases in the record suspension fee, which meant that people couldn't apply. So it is in the budget. There's 700 pages there, so I'm not surprised if you may have missed that, but it is something that we're committed to changing. I just want to thank all the witnesses today for your testimony. You've been talking a lot about people, Indigenous peoples, Black Canadians, racialized Canadians who are disproportionately impacted by their being touched by the criminal justice system. I mean, it costs us $330 a day to put someone into prison, and that's not the place where most of them need to be. Because you brought those issues up, I want to focus on Bill C-22, because that bill does include reducing mandatory minimum sentences, drug diversion, conditional sentences, dealing with a number of issues that you've all touched on as being of concern. There was a study that was done of 44 Indigenous women who are the fastest growing prison population in Canada, who received conditional sentences prior to 2012. And it was found that 36 of them would have been ineligible to receive a conditional sentence under the Harper government restrictions. I met 2 of them when I visited the Edmonton Institute for Women that should not have been in jail. And because they were in jail, it was going to impact the rest of their lives. So I'm just wondering if each of you could maybe talk a little bit about how important it is to get Bill C-22 passed and passed quickly. Go ahead, Chair.
That was Mr. Lafond, I believe. Go ahead, sir.
Sure, I can chime in on this one. So Bill C-22, again, we've had a lot to say to the Minister's office on this point specifically, in our written correspondence outlines that while we're pleased to see some changes that reflect some of the calls to action, specifically call to action number 32, there's nothing of any substantive or systemic value in Bill C-22 or Bill C-23. We've raised 16 points, 10 immediate action points that need to be addressed on today. They need to be addressed immediately. They've been studied extensively and repeatedly and set out in, again, 21 commissions, reports, and studies over the last 30 years. And the problem that we have with Bill C-22 and 23 is that the scope of its focus is too narrow, doesn't focus on any of the systemic items that we've identified need to take place immediately. Just to name a few, I've named 10 already in my initial presentation, but there are others that we've communicated, addressing over policing and over criminalization of Indigenous peoples, implementing a multi-pronged Indigenous de-escalation strategy, and ensuring appropriate systems are in place to carefully and systemically investigate reports of crime and violence against Indigenous victims. Like these are systemic items that have been identified on numerous occasions, and what we lack right now is implementation.
Thank you. Although mandatory minimum sentences, drug diversion and conditional sentences are also important to get. I'm not arguing with you that there's a lot more that needs to be done, but I think for a number of people who come in contact with the criminal justice system, those would make a difference. I'm wondering if Mr. Brown or Mr. Sealy-Harrington wants to add any comments.
Madam Chair, I'm happy to address this. I can say that we really do applaud the government for introducing these changes to conditional sentences. I think that's going to make a huge difference. $330 a day. In fact, it's on average about $100,000 a year to house an inmate in custody. That $100,000 a year can be used for education programs, for addressing at-risk youth, even for hiring a prosecutor to get through some of these other cases. But there's absolutely no reason not to bring these types of things back and to allow more people to simply resolve their cases without having to go to trial to avoid these mandatory harsh jail sentences.
I don't think I've got time for, does Mr. Sealy-Harrington have time to respond, Chair?
15 seconds or less.
Madam Chair, I'll just say I spoke with Senator Kim Pate about my concerns about Bill C-22. So if you listen to that interview, you'll be able to hear a detailed discussion about my support of certain aspects of it, but also my significant concerns with it.
Thank you. Thanks very much, Ms. Damoff. We'll now go to Monsieur Fortin for 2.5 minutes. Go ahead, sir.
Merci, Madame la Présidente.
Thank you, Madam Chair. Well, I agree with Mr. Moore. We've been talking a lot about the administration of the justice system, and obviously, and I agree with what the witnesses said, there are things that need to be improved around barriers and so on. There are some things that are considered offenses that shouldn't be. Now, that being said, if we talk specifically about the problem that we're experiencing during COVID, of course, all of this was compounded by the pandemic. But I'm interested in this question. That is virtual hearings. I'd like to hear Mr. Brown speak to this. I understand that there's a significant impact on evaluating the credibility of witnesses, but I would like to understand what are the benefits that you see and what are the disadvantages of a hearing if it's at least in part done virtually.
Madam Chair, I mean, one of the benefits absolutely is the fact that it's easy to get everyone in the same place at the same time. People don't have to necessarily travel from far distances. One of the other benefits we hear from judges is just the ability to see everyone's face at the same time. Often a piece of evidence is heard and the judge is trying to look in various places in the courtroom, trying to gauge the reaction of the parties, to watch the witness, to watch the accused person. And so this allows an opportunity to see the whole room. Those are the benefits. I mean, the disadvantages is that we don't know what's happening behind the scenes, and there may be cases where, and we've certainly seen examples in the U.S. where a witness is testifying and the accused person is in the next room coaching them, and so we do have some concerns about privacy and about whether or not the integrity of the system is being undermined in some cases. But that's I think there are lots of advantages to focus on.
Est-ce que ça n'aide pas en matière?
Now, does this not help with dealing with the backlog? Does it not remove some barriers because you can proceed quicker when you have virtual hearings, in your opinion?
In our experience, the resources that are required to run a courtroom, the staffing, the judges, they don't change just because we've removed it from a physical courtroom to a virtual one. So even though, so the problem isn't the courtroom space, it's the people that need to be in the courtroom to process the case, and that hasn't changed.
Non, je comprends, mais ouais, merci.
Merci, Monsieur Fortin.
Thank you, Mr. Fortin.
Last but not least, Mr. Garrison for 2.5 minutes. Go ahead, sir.
Thank you very much. Earlier this week, we heard some disturbing testimony from the Elizabeth Fry Society about the impacts of COVID on those, the legal rights of those who are incarcerated at this time. And she talked about sustained lack of access to legal counsel. She talked about delays and problems with access to parole hearings. And I had a separate meeting with the Congress of Aboriginal Peoples, which raised those same concerns. So I'd like to ask Mr. Lafond to comment on the impacts of COVID on the access to the legal system and to legal counsel for those who are already incarcerated.
Thank you for the question, Mr. Garrison. I'd like to just harp back to the study or to the results of the study that we performed at the University of Saskatchewan, and which spoke primarily to jurisdictional issues. Now, there were concerns raised about case delays and how processes which have since slowed post-COVID have had the effect of deferring the assertion or development of Indigenous rights. Now, with respect to specifically the delays on the justice system and the ability of accused to have their cases heard in a timely manner, this wasn't a central focus of the participants in the study. Was primarily dealing with respect to the assertion of jurisdictional issues and the ability for different jurisdictions to cooperate with one another to have these have matters of conflict mediated or adjudicated in a timely fashion.
Thank you very much. I wonder if other members of the panel have run into this problem of lack of access to legal counsel and inability to access legal rights for those who are incarcerated during COVID.
I could address that, Madam Chair, very briefly. It is a serious issue. As you know, jails are meant to keep things out. They have very thick walls, and it's even hard to run wires in, we're told. So the lack of communication to the jails is a serious problem. We've been working with the regional justices. We've been working with the Ministry of the Attorney General and Solicitor General to try and solve it. But communication is key to get things moving, us with our clients and with the Crown attorneys. And so as a result, if we don't have the ability to get in by video to show disclosure and by audio to get instructions, it will slow things down. So an investment in communication would be very welcome. Thank you.
Thank you very much for that. So that concludes our rounds of questions. At this time, I'd like to thank our panelists, our witnesses for your very compelling testimony today. If there is any shortcomings or anything you'd like to clarify, please do provide written submissions to Mr. Clerk. We're happy to receive them. Thank you, everybody. And at this time, the meeting now stands adjourned.